Heavenly Father, thank you for giving us this wonderful day. Thank you for granting us another chance to see each other and be able to learn daily. We ask for your guidance and help us achieve the goals set for today. Shower us with your love and support, strength, and perseverance to continue living these challenging days. It's all we pray in the mighty name of Jesus, our Lord. Amen.
Hello and good afternoon to all of you. We are Group 1 and I am joined by my group mates, Samantha Nicole Barreto, Kervin Carlo Magpantay, Bridge Mulan Sabaliana, and Therese Margaret Miranya. Together, we will be reporting about the wide scope of physical evidence. But before that, what is physical evidence? Physical evidence refers to any material, object, or substance that can provide information relevant to a investigation. This evidence can be collected at a crime scene and can include items such as DNA, fingerprints, fiber, hair, blood, or firearms. Physical evidence can provide important clues about a crime and can be used to link a suspect to the crime scene, identify a weapon or tool used in the commission of the crime, or provide information about the timing or sequence of events. Forensic scientists use a variety of techniques to analyze physical evidence, including DNA analysis, fingerprint analysis, ballistics, and trace evidence analysis. These analyses can help investigators build a case against a suspect or exonerate an innocent person. Overall, physical evidence plays a crucial role in the investigation and prosecution of crimes and can provide valuable insights into what really happened at a crime scene. However, in this report, we would only be focusing on the forensic medicine aspect of physical evidence, which is the type of wounds and body fluids, as well as DNA analysis. With that said, our report will be divided into two parts. For the first part, we would be discussing wounds as physical evidence. This includes different types of wounds, the difference between blunt forces and sharp forces, as well as wounds due to the chemicals. This also includes how wound as physical evidence should be photographed and measured, wherein different vantage points will also be tackled. For the latter part, the different types of body fluids will be tackled and how it is utilized as a physical evidence. Consequently, collection of evidence and its proper handling and preservation will be discussed. Likewise, collection of wet and dried blood will be mentioned. We will also be discussing the admissibility of physical evidence in court and how it should be properly handled through the chain of custody. And lastly, we will also talk about Rule 21 of the Rules of the Court that elaborates on subpoenas and the role of an expert witness when called to testify in the court in relation to physical evidence. And now, let me call on Kervin Carlo Magpantay to start the discussion proper.
Good afternoon, guys. Good afternoon, Doc. I am Kervin Carlo Magpantay. Allow me to report the different types and characteristics of injuries. To add up to what Lourdes has said, maraming iba't ibang uri ng physical evidence, be it fingerprints, bullets, hairs and fibers, body fluids, and even acquired wounds can all be used as physical evidence. But allow us to focus more on wounds and bodily fluids as physical evidence, since these are some of the few pieces of evidence na may malaking value sa court trials. Injuries and wounds are both generic terms. Um, as, as defined, a breakdown in the protective function of the skin, the loss and continuity of epithelium with or without loss of underlying connective tissues such as the muscle, bone, and nerves, following injury to the skin or underlying tissues, organs caused by surgery, a blow, a cut, chemicals, heat or cold, friction or shear force, pressure, or as a result of disease. Sa likod naman ng wounds or injuries, marami pang iba't ibang uri ng mga ito. Pero paano nga ba sila nagagamit sa court? Kapag ba may sugat ka nakita sa victims or cadavers, pwede na agad ipakita sa court? In this part of the report, we will dig deeper to that. We will familiarize the different types of wounds, how it is photographed and measured, and the certain rule prescribed by law on how to use medical evidence as physical evidence in the court. Just what I have said, these are the different types of wounds. Pwede sila maging due to mechanical force, due to thermal, chemical, or even injuries due to lightning, electricity, and even radioactive substances. Under mechanical force, we have blunt force and sharp force. Under thermal, we have cold and heat. Under chemical, we have acids and alkalis. And we will dig deeper to mechanical force. So first, let's have chemical factors. There are certain crimes involving chemicals. One example is during revenge crimes kung saan si perpetrator ay may gumagamit ng mga chemical bilang daan para makapaghigante sa involved party. In chemical factors, damage to the body from a caustic chemical, which is a very strong acid or base that can burn or corrode. Contact with these chemicals can damage the skin, eyes, lungs if breathed, or if swallowed the inside body. Chemical factors can either be acid or alkali. In acid burns, tissue damage caused by strong acids, drain cleaners, paint thinner, gasoline, and many other substances. On the other hand, for alkali burns caused by eye or for example drano and liquid plumber, lime or ammonia, in addition to other agents, they are characterized by liquefaction necrosis. They are worse than acid burns because the damage is ongoing. It is also noted na mas worse daw ang burn na naibibigay ni alkali compared to acids dahil sa ongoing penetration nito sa katawan. Kumbaga, kung si acid ay nagtatagal ang pagsunod sa balat ng mga ilang segundo, si alkali naman continuous yung penetration niya sa skin at mas tumatagal compared kay acid. Next, we have the thermal factor. Ito naman ay maaaring injuries dahil sa malamig or mainit na temperature. As defined, thermal factor, injury occurs when energy is transferred from heat source to the body, causing an increase in the temperature of local tissue. When tissue temperature rises above a certain threshold, irreversible cellular injury will occur with interruption of metabolic process. For cold temperature, we have frostbites. Frostbites is the injury to the body that is caused by freezing. Frostbite causes a loss of feeling and color in affected areas. The skin turns white or blue-gray, and you lose all sensation of cold, pain, or discomfort in the area. Joints or muscles may stop working. Large blisters form 24 to 48 hours after rewarming. The tissue turns black and hard as it dies. In worst case scenarios, ina-amputate na yung mga part ng katawan na nagkaroon ng frostbite. For thermal burns naman, skin injuries caused by excessive heat, typically from contact with hot surfaces, hot liquids, steam, or flame. Ito naman yung usual na na-acquire sa mga crime scenes na may sunog. Its appearance will vary depending on the degree of burn. Next, we have mechanical factors. Mechanical factors includes the use of weapon or instruments such as knives, screwdrivers, scissors, razor blade, glass or guns, and injuries result from falls, traffic accident, or domestic violence. In here, you can see that there are three major category of forces under mechanical force. First is the blunt forces, then followed by sharp forces and firearms. Before we go to the specific types of mechanical force, let us note that the word injury mechanism ay isa sa mga basehan ng medico-legal experts when testing or checking the characteristics of wounds. As defined, injury mechanism refers to the various forces commonly associated with trauma. For example, the projectile, whether the object is sharp or blunt, thermal, and polytrauma. Kapag kasi meron tayong accurate identification of mechanism, we can conclude the pattern recognition as well as the contributions of intrinsic and extrinsic factors that indicates the way of wounds or injuries. For blunt force trauma, on the body due to blunt forces or instruments, these injuries are on skin and scratches, gazing, bruising are observed. First type of mechanical force is the blunt force trauma. Example of situation kung saan papasok si blunt force trauma ay ang injury kapag hinampas ni perpetrator si victim ng baseball bat. Kung saan usually hindi siya nag-end up into open wounds. Instead, internal yung nagiging effects ng blunt force trauma. Pero meron pa din naman tayo mga specific type of blunt force trauma na nagbibigay ng open wound. First type of blunt force trauma is the abrasion. In this type of injuries, the outer layer of the skin is carved off. Examples of the abrasions are scratches, grazing of the skin caused by dragging, imprint caused by belt, hunter sticks, or even hunter sticks. Another example, si letter A ay nagsasuffer sa domestic violence. Madalas siyang binubugbog at kinakaladkad ni letter B. Kung kaya nagkakaroon siya ng multiple na mga sugat. At isa doon sa uri ng sugat na nakuha sa kanya is yung abrasion. Ito yung mga gasgas sa balat niya dahil sa pag-scrape ng skin surface niya sa isa pang surface. Next, we have the contusion. This type of injuries occur when blood vessels in the skin or internal organ are ruptured. Ito naman yung tinatawag natin sa Tagalog na pasa. Other term for this is bruises. Usually, isa sa mga sugat na nakukuha ng victims of hazing, kapag paulit-ulit silang pinapalo ng platform, hindi man nagkakaroon ng open wound, nadadamage naman yung inner surface ng kanilang balat. And even the blood vessels, kung kaya nagkakaroon ng discoloration kapag nagtatagal. At first, its color is red. After few hours to 3 days, it is converted into blue. On the 4th day, it changes into bluish black. When bruising is extensive and deeply situated, meaning masyadong malala, the color takes longer to appear externally. Next type of blunt forces is the lacerations, tears or splits of skin, mucous membranes, muscle, or internal organs produced by application of blunt force to the body. There are two types of laceration. First is the split laceration, which is the crushing of the skin between two hard objects. For split laceration, nakukuha to usually kapag masyadong nagkakaroon ng malakas na force. For example, si victim ay tumatakbo dahil hinahabol ni perpetrator. Unfortunately, sa pagmamadali niya, masyadong lumakas yung force ng pagtapak niya. Dahil doon, nagkaroon ng laceration yung paa niya, parallel to a cut. The next type of laceration is the stretch lacerations, wherein it is the overstretching of skin that may end up being avulsion or tears. On the other hand, this kind of laceration, dahil nga sa excessive stretching ng skin, nagde-detach ang skin from which sometimes results to avulsion. Wherein avulsion ay yung uri naman ng wound kung saan halos humihiwalay yung flesh sa katawan. For our next type of mechanical force is the sharp force injury. These are caused by cutting or stabbing the skin with sharp instruments or weapons, such as knives, swords, pins, broken glass bottles, razor blade, and tools like screwdriver. And there are three types of sharp force injuries explained as under. Literally, dahil sharp objects, kaya nagkakaroon ng sugat under the sharp force injury. First type of sharp force injury is the incised or cuts. This type of wound is a superficial injury in which the size of the injuries on the surface is larger than the depth of the injuries, generally made of razor blade, axe, and swords. Ito yung sinasabi ko kaninang ka-counterpart ni laceration ng blunt force trauma kay sharp force injuries. Normally, nakukuha to dahil sa sharp objects. Next type is stab, penetrating, or puncture. Produced from the penetration of pointed or sharp instruments or weapons onto the depth of the body that is deeper than its length, generally knives, broken glass bottles, and tools. And this kind of wound naman, compared to incised cuts, mas malalim ang length ng sugat. Dito din pumapasok yung animal bites or paggamit ng syringe kung saan nagkakaroon ng puncture sa katawan. Next, we have fractures or dislocation. It is a break usually in a bone. If the broken bone punctures the skin, it is called an open or compound fracture. This kind of wound naman, pumapasok siya both sa blunt force trauma at sharp force injury. Normally, nangyayari sa vehicular accidents. Fractures can either be exposed sa outside surface ng skin or sa inside lang. Next is the last part of the mechanical force, which is the firearms. For gunshot, it is the injuries produced by firearms vary depending on the projectile, the muzzle velocity, distance, angle of the firing, and part of the body involved. Depende sa uri ng firearm, layo ng perpetrator at angle ng pagputok, nagkakaroon ito ng iba't ibang karakteristik. In gunshot wounds, we have entry and exit wounds. Nagkakaiba sila sa itsura dahil sa binibigay nitong pressure sa katawan. In most cases, mas clean or mas malinis at rounded ang entry wound compared to exit wound dahil focused pa ang force ng bala sa isang specific part ng katawan. In contrast to entry, mas malaki naman at mas scattered yung edges ng sugat dahil lesser na yung force ng force ng bala sa katawan kung kaya nagreresulta sa mas malaking sira sa balat. In this part, makikita naman natin na may malaking effect talaga ang distance ng barrel sa sugat. In the first picture, excuse po, may naka-open mic po ata. Kuya Curvy pa, yan, okay. So, again, in the first picture, self-inflicted siya. Meaning, sobrang liit lang nung distance ng barrel sa victim. Kung kaya kung makikita niya sa picture, mas malakas yung blow ng bala at nagkaroon ng malaking damage kahit entry wound pa lang. Compared to that, the second picture shows a gunshot wound kung saan mas malayo ang barrel, making the entry wound clean or making the entry wound clean cut. Allow my companion Blitz Mulan Sabiliana to continue my report. Thank you.
Hi, good day every day. I'll be discussing the following documentation and measurement of wounds as physical evidence. First is the mid-range photographs. The documentation of physical evidence using mid-range photographs involves taking photographs of the items of evidence and their spatial relationships in a crime scene. The purpose of these photographs is to show the context, perspective, and scale of the evidence and to establish the precise position of each item of evidence. To take these photographs, a single item of evidence is selected and then depicted in relation to a fixed object in the scene, such as a wall, floor, or a piece of furniture. This fixed object serves as a reference point that allows viewers to understand the spatial relationship of the evidence to the surrounding environment. The photograph should be taken from a mid-range distance that shows the item of evidence clearly while also providing enough background to establish the context of the scene. The camera should be positioned at a height and angle that accurately represents the perspective of the viewer. Properly documenting physical evidence using mid-range photographs is important in ensuring that the evidence is accurately represented and can be properly analyzed and interpreted by investigators, forensic experts, and legal professionals. It can help to establish the chain of custody of the evidence and its relevance to the crime under investigation. Next is the close-up photographs. Close-up photographs are a type of physical evidence documentation that involves deliberate depictions of individual items of evidence. These photographs are taken to capture detailed images of the evidence that can reveal important identifying features or help to establish the chain of custody. To take a close-up photograph of an item of evidence, the camera should be positioned as close to the item as possible, while still allowing all sides of the item to be visible in the photograph. The photograph should be focused on the item to ensure that all markings, defects, or other identifying features are clear and visible. Close-up photographs are especially important in cases where the evidence is small or intricate, such as fingerprints, fibers, or tool marks. They are also useful for capturing images of damage or wear on an item that may be relevant to the investigation. It is important that close-up photographs are taken from multiple angles to ensure that all sides of the item are properly documented. The photograph should also include a scale or ruler to provide a reference for size and distance. By capturing detailed and accurate images of individual items of evidence, close-up photographs can help to establish the relevance and significance of the evidence in the investigation. They can also serve as important visual aids in court proceedings, allowing legal professionals and jurors to better understand the evidence and its implications. Next is the close-up photographs with scale. Documentation and measurement of wounds is an important aspect of physical evidence collection in cases involving injuries or assaults. Close-up photographs with a scale are often used to document and measure the size and location of wounds. To take a close-up photograph with a scale, the camera should be positioned as close as possible to the wound without compromising the image quality. A scale or ruler should be placed next to the wound to provide a reference for size and distance. The photograph should be focused on the wood to ensure that all details are clearly visible. Close-up photographs with a scale are important because they provide an accurate and objective record of the wood that can be used as evidence in the court. They can help to establish the severity of the injury, the location of the wound, and the type of weapon or object that may have caused the injury. These photographs are typically attached to the case folder and presented as exhibits during the court trial. They are used to support the testimony of medical professionals and other experts, and to help jurors understand the nature and extent of the injuries. By documenting and measuring wounds using close-up photographs with a scale, investigators can create a comprehensive record of the physical evidence that can be used to support the prosecution or defense in a criminal case. Next is bodily fluid as physical evidence. Bodily fluids are a vital component of a physical evidence in many criminal investigations. Blood, semen, saliva, and urine are commonly collected and analyzed to provide valuable information about a crime and those involved in it. The analysis of body fluids can help to identify suspects, determine the cause of injury or death, and provide critical information to assist in the prosecution of a criminal case. Proper collection and analysis of bodily fluids is crucial to ensure the integrity of the evidence and prevent contamination. In this context, the use of bodily fluids as physical evidence can play a crucial role in the pursuit of justice and the protection of society. There are two types of bodily fluids. Bodily fluids can provide critical information that can help to identify suspects, establish a cause of death or injury, and provide evidence for a range of crimes from sexual assault to drug use. So here are some of the most common types of bodily fluids used as physical evidence. First is blood. Blood is commonly collected bodily fluid in criminal investigations. It can be used to identify suspects through DNA analysis, establish the cause of death or injury, and provide evidence of a range of crimes from homicide to assault. Blood can also be used to link suspects to a crime scene through the presence of spatter or transfer stains. Next is semen. Semen is another commonly collected bodily fluid in sexual assault investigations. It can provide DNA evidence that can be used to identify suspects and can also provide evidence of consensual sexual activity. Semen can be collected from clothing, bedding, or the victim's body. Next is the saliva. Saliva is a valuable bodily fluid that can provide DNA evidence to help identify suspects. It can also provide evidence of physical contact between a suspect and a victim or a crime scene. Saliva can be collected from bite marks, cigarette butts, or discarded chewing gum. Next is urine. Urine can be used to detect the presence of drugs or alcohol in a suspect's system. It can also provide evidence of drug use or distribution and can be collected from containers, clothing, or drug paraphernalia. For further understanding, Ms. Maranya will provide a concise explanation on how bodily fluids are crucial evidence in a criminal investigation.
Wait lang po, nagkakaroon lang po ng trouble sounds. Hello?
Hello, my name is Margaret Maranya, and I'm here to further explain bodily fluids as evidence. So, the most common bodily fluids to be found in these instances are blood, semen, serum, saliva, and sometimes, given the severity of the crime, urine and feces. Now, dito sa part na to, ina-explain lang niya na bodily fluid is used as evidence because these fluids can provide valuable information about the crime scene and can help identify suspects. Sinabi nga din kanina ni Ms. Avellana na ang ating bodily fluid ay galing siyempre sa atin. And dahil galing siya sa atin, nagagamit siya as evidence. And the most commonly used body fluid is blood. Now, for the second part, bodily fluids can also provide information about the nature of the crime. What this means is that yung information about the nature of the crime is that it can show possibility to police investigators or forensic investigators how and what could have possibly happened in a crime scene. For example, yung puddle of blood dito sa picture natin. Yung puddle of blood na to, pwede siya mag-indicate na let's say, nahulog sa floor yung victim or yung suspect tapos nag-bleed out siya. Kaya meron siyang puddle of blood dun sa area na yon. Or pwede din tumigil siya saglit dun sa spot na yon na duguan siya. Kaya ang nangyari, nag-pool yung mga blood na nag-drip sa kanya. Another very important example here is that halimbawa, sa isang crime scene, may na-discover silang semen or human semen. Now, yung semen na yun could provide information to the investigators na may possibility na may nangyaring sexual acts or worse, rape na nangyari kaya merong semen doon. Those are just one of the examples of how bodily fluid provides information about the nature of the crime. Now, lastly, all personnel must be fully clothed in protective clothing to avoid contamination of the crime scene. And it is important to note that the collection, handling, and analysis of body fluids as evidence must be done carefully and accurately to avoid contamination or other errors that could compromise the results. This last one just shows that bodily fluids can only be used as evidence if it is handled properly and there are no contamination or errors within the evidence. Kasi at the end of the day, kahit na sobrang dami mong nakuhang bodily fluids that would help serve as evidence, pero lahat ng yan ay na improperly handled or nasira yung sinasabi nating chain of custody, masasayang lang lahat yung evidence at mababaliwala sila. So this last one is just a reminder that bodily fluids can only be evidences if it is properly handled. Now I will be giving back the presentation to Miss Bridge Mulan Sabilyan.
So for the documentation and collection, when collecting physical evidence in criminal investigation, it is crucial to use the proper containers to preserve the integrity of the evidence. Here are some key points to consider when packaging and transporting evidence. Most items of evidence are collected in paper containers such as pockets, envelopes, and bags. This helps to prevent contamination and preserve the evidence. Second, liquid items can be transported in non-breakable, leak-proof containers to prevent spills and contamination. Third is moist or wet evidence such as bloods or plants can be collected in plastic containers at the scene. However, the storage time in plastic should be 2 hours or less to prevent contamination of other evidence. Fourth, items that could cross-contaminate each other must be packaged separately. The containers should be closed and secured to prevent the mixture of evidence during transportation. And lastly, each container should be clearly labeled with the collecting person's initials, the date and time it was collected, a complete description of the evidence and where it was found, and the investigating agency's name and their file number. This information helps track the evidence and ensure its integrity. Next is wet blood and body fluid stains should be collected in the following manner. Suppose that investigators arrive at the crime scene and find a wet blood stain on the carpet. Here is an example of how they might collect and package the wet blood stain. First is put on gloves and a mask to prevent contamination. Second, take photographs of the blood stain to document its location and size. Third, use a sterile cotton swab to collect a sample of the wet blood stain. Fourth, absorb the remaining blood stain it onto a small 1 by 1 square of reclaimed 100% cotton sheeting. Fifth, place the cotton swab and the cotton sheeting in separate labeled paper envelopes. The envelope should include the date, time, location of the stain, and the name and initials of the collector. Six, bring the envelopes to a secure location and allow them to air dry completely. Seven, once the evidence has dried, repackage the envelopes in a larger labeled paper bag or envelope. Eight, if the transportation time is under 2 hours, plastic bags may be used to transport the evidence. And lastly, store the evidence in a secure location to maintain its integrity. By following these steps, investigators can collect and package the wet blood stain in a way that preserves its integrity and prevents contamination. This evidence can be analyzed in a laboratory to help solve a crime. Next is the dried blood and body fluid stains should be collected in the following manner. If the stained object can be transported back to the crime lab, then package it in a paper bag or envelope and send it to the lab. If the object cannot be transported, then either use fingerprint tape and lift it like a fingerprint and place the tape on a lift back. Scrape the into a paper pocket and package it in a paper envelope. Or absorb the stain onto 1/2 long threads moistened with distilled water. The threads must be air dried before permanently packaging, and for transportation purposes and to prevent cross contamination, the threads may be placed into a plastic container for no more than 2 hours. Once in a secure location, the threads must be removed from the plastic and allowed to air dry. They may then be repackaged into a paper pocket and place it in a paper envelope.
Hello? Hello, I'm Margaret Maranya, and I'll be taking over the presentation again. But before that, let's introduce forensic serology. Forensic serology. the branch of forensic science that deals with the study of bodily fluids, such as blood, semen, saliva, and other bodily fluids for the purpose of identifying biological evidence in criminal investigation. For further explanation on the topic of forensic serology, Ms. Avellana again will be presenting and giving light on this topic.
So forensic serology is the branch of forensic science that deals with the identification, characterization, and analysis of bodily fluids such as blood, semen, saliva, and other biological materials that may be found at a crime scene. Serology is the study of the properties and reactions of serum, which is the clear liquid that separates from blood when it clots. It can be used to determine the blood group of a person or the presence of specific proteins and enzymes in a bodily fluid. In addition to blood typing and protein analysis, forensic serology may also involve the detection and analysis of DNA in bodily fluids. DNA analysis has become an increasingly important tool in forensic investigations and can be used to definitively link a suspect to a crime scene or to exonerate an innocent person. Forensic serology involves the application of various medical fields and methods, including immunology, hematology, genetics, and molecular biology. Forensic serology testing begins with presumptive tests. These presumptive tests, preliminary tests, establish the possibility that a specific bodily fluid is present. Presumptive tests includes blood detection, semen detection, urine detection, and many more. Forensic serology also does confirmatory tests in order to conclusively identify the identity of the biological material. A forensic serologist uses various techniques to analyze and compare the physical and chemical properties of biological materials found at crime scenes with those of known samples to determine their origin and to help link suspects to crimes. Some of the common techniques used in forensic serology include blood typing, DNA analysis, and enzyme assays. The information obtained through forensic serology can be used to help identify suspects, establish link between suspects and victims or crime scenes, and provide important evidence in criminal investigations and trials. For the analysis of the bodily fluid, Ms. Therese Margaret will elaborate the following tests and analysis of this topic.
Hello, once again, I'll be taking over the report. So, ayun, sinabi niya na ang forensic serology, ang ginagawa nito ay identification and confirmation na kung ang isang bodily fluid nga ba ay present sa isang crime scene ay galing sa isang tao. And with that, yung identification and confirmation na yan is actually yung dalawang test din na nabanggit niya na kinoconduct sa forensic serology. So, yung first test na sinasabi natin dito ay ang presumptive test. Ang presumptive test ay ine-establish niya yung possibility that a specific bodily fluid is present. Presumptive test includes blood detection, semen detection, urine detection, and etc. Bale, ang presumptive test ay yun nga, ni-establish niya kung may presence nga ba or may absence ng isang bodily fluid sa isang crime scene. Yung means of establish niya is by identifying and using different types of tests. Kaya nga siya tinawag na presumptive test. For example, sa isang crime scene, para ma-determine kung may presence of bodily fluids, ay nagamit sila ng katulad itong blood detection, itong luminol test na nasa slide natin, semen detection, katulad itong Walker test, kung may mga bodily fluids nga ba. And ito na nga, I-explain ko na, ang actual example nito is itong luminol test. So, sa ating luminol test, ang lagi nating nababanggit, nagamit siya ng isang chemical compound na tinatawag nating luminol, na para tignan kung ang isang surface or isang place or isang object nga ba ay meron tinatawag na hematine. At ang hematine ay isang substance na pag nilagyan mo ng luminol, ang tendency nito is mag-glow. At ang hematine ay isa siya sa mga substances na nagbe-make up sa ating blood. So, bale, pag ang hematine at ang luminol ay nag-combine, ang mangyayari magkakaroon ng glow. And that glow represents that merong blood dun sa isang surface na yon. And ang ginagawa natin, pag nag-glow yung isang surface, yung luminescence na to, ay naglala siya for several minutes at pwede natin siyang i-photograph, katulad ng sinabi kanina sa documentation, para magamit as physical evidence. And now, for the Walker test naman, yung luminal test is used uh, for blood. Now, for Walker test, ginagamit naman siya for the identification of human semen. Now, yung human semen kasi, similar siya sa blood na meron silang substances na mostly na makikita lang sa kanya. And kung sa blood ay yung hematine, dito sa semen naman ay may tinatawag tayong substance called acid phosphatase. Now, yung test na to, ang ginagawa dito ay kukuha sila ng isang filter paper. Kung kita nyo sa picture, itong color white na bilog na mukhang ostya. Tapos, yung suspected bodily fluid na yun, isa-swab nila, tapos ilalagay nila dun sa gitna ng filter paper. Kung kita niya, may nando sa gitna ng filter paper. And then, magda-drop sila ng reagent dun sa suspected body fluid. Ngayon, pagka-drop nila ng reagent na yun, there are two possibilities na mangyari. Una, magiging color purple yung bodily fluid, katulad ditong nasa picture sa right side. And pag nag-purple siya, it means that positive yung naging test niya or yung reaction niya, and pwede natin makuklod na semen yung bodily fluid na yon. Pero pag there is no color or wala nangyari, walang violet color, katulad na nasa left side, meaning negative reaction siya, and therefore hindi siya semen. And that's all for the two tests. Pero before I move on, i-mention ko lang. Ang presumptive test, yes, pang-establish siya kung present ang bodily fluids. Pero dahil presumptive or preliminary pa lang siya, kahit na nakaka-provide siya ng possibility na may specific bodily fluid present, it does not mean na wala siyang cons or precautions. And what I mean by that is, the thing with presumptive test is that at risk siya of false positives and they may be overly sensitive. This means that kahit na na-establish na may bodily fluid or let's say blood sa isang crime scene, it does not prove, uulitin ko, it does not prove na yung blood na nakita sa crime scene na yan is actually blood. Kasi itong luminol and Walker test has their own limitations. Like sa luminol, pag may copper ang isang suspected bodily fluid, may possibility na magbigay ito ng false reaction or aka mag-glow siya kahit hindi naman talaga siya dugo. And sa Walker test din kasi, ang mga vaginal secretions and other bodily fluids na nagko-contain ng acid phosphatase, magiging detectable din siya under this test at magiging purple din siya. Kaya ngayon, the question here is presumptive test still useful knowing na may mga limitations siya? And the answer is yes, it is still useful. And pero para magamit ang kanyang full capacity, dapat ang presumptive test ay ginagamit natin para makaprovide lang ng initial information to determine what test to perform next. Hindi natin siya pwede gamitin na para sabihin natin na blood na agad yon. And kaya nga sinabi natin dalawa yung testing natin dito kasi ang presumptive test ay ginagamit in confirmation with the confirmatory test, which is the next type of analysis. So, this is the second type of test na ginagawa, the confirmatory test. So confirmatory tests are done to conclusively identify the identity of the body fluid in question and lessen the risk of false positives. So a confirmatory test by itself is pang-confirm kung yung bodily fluid na na-detect ba dun sa presumptive test is actually the body fluid. Kasi di ba nga sabi ko, hindi 100% garantisado ang presumptive test. So dito natin mismo gagamitin na pang-check kung yun nga ba talaga yon. Kung sa presumptive test, pwede natin ma-establish na this bodily fluid could be blood. Dito sa confirmatory test, check talaga natin kung blood ba talaga yon or it's some kind of other bodily liquid. So ang confirmatory test natin, marami din siyang iba't ibang examples or test na ginagawa. Pero dito sa ating example ay ang RSID test for human blood and RSID test for human semen. And yes, same sila ng test. Okay. So, i-define ko muna what is the meaning of RSID. RSID means Rapid Stain Identification Test. Test siya for 4 types of bodily fluid. Blood, saliva, semen, and urine. Na nagamit ito ng what we call lateral flow immunochromatographic strips. Or basically, it's just a strip test specifically designed for the checking of bodily fluid for forensic use. Ang itsura nitong RSID test is itong nasa picture na mukhang pregnancy test. And yes, ganito talaga siya. Ngayon yung mga RSID, pare-pare sila kung paano siya gamitin. So, paano ba gamitin ng isang RSID? So yung S sa baba, dun dito sa picture, ang meaning ng S na yun is sample. And by sample means dun mo ilalagay yung sample bodily fluid mo. Yung C is yung control band, ito yung pang-control dun sa test. And yung T naman is yung pinaka-important, which is the test band. Ito yung pinaka-titignan mo if yung bodily fluid is positive or negative. So, explain ko lang tong apat na pictures. So, pag before test, dapat walang indication siya. Well, ayan lang, blank lang siya. Tapos, pag negative result naman, yung control strip lang, yung letter C lang yung may line dapat. Pag positive siya, para siyang sa pregnancy test, dalawang lines ang magpapakita. Parehas dun sa control and sa test bands. And lastly, pag failed test or nag-error siya, yung letter T lang, yung dun sa may, or yung test band lang yung may line. And now, yung for RSID ng blood, explain ko lang kung paano siya talaga nangyayari. Yung for RSID ng blood, yung test niya is may antibodies that specifically recognize a protein called glycophorin A in human blood. Then, yung mixture na to, ma-add siya dun sa small window below dun sa testing strip. Ngayon, may isa pang separate antibody that also recognizes glycophorin A that attached naman dun sa line ng testing strip. Ngayon, pag yung glycophorin A is present dun sa sample bodily fluid na ilalagay mo dun sa test, magbabind siya dun sa antibodies na nakalink dun sa small window. Tapos gagalaw siya along dun sa testing strip at magbabind naman yung antibodies na yon dun sa test site. Kaya ang mangyayari, magkakaroon ng visible red line, indicating na merong presence of human blood. Para naman sa RSID na semen, same lang siya na nangyayari. Ang difference lang niya is kung glycophorin A, yung nire-recognize niya, dito naman sa semen, ang nire-recognize niya isang protein called semenogelin in humans. At ayun lang naman ay isang protein na makikita sa human semen. And that's all for confirmatory test. Now, I would just like to add something din sa analysis of bodily fluids, which is DNA analysis. So, DNA analysis, lagi natin ito narinig. Ang first thing na siguro para ma-discuss natin to is, what is DNA analysis? Para masagot natin to, let's start with its basics. Ang ating DNA, or what we call deoxyribonucleic acid, is made of 4 building blocks or what we call nucleotides. Yung nucleotides na yun ay adenine, cytosine, guanine, and thymine. Thymine and adenine, nag-a-attach sila sa pair, as a pair, and guanine and cytosine, they also attach as a pair. Now, itong pairs na to, the sequence of pairs, they act as a set of instructions that makes, siya that makes us, makes all living things. Ngayon, ang DNA analysis naman, interpretation siya of genetic sequences, aka interpretation siya nung sinabi ko lang pairs, and pwede siya magamit for a wide variety of purposes. Ang DNA analysis, sabi ni kanina, it can be used to identify a species or but also differentiate individuals within a species. Ang DNA then can be used to examine an individual's DNA to identify genetic variations, mutations, or features that can provide information about the person's identity, biological relationships, and etc. Ngayon, paano nga ba ginagawa tong DNA analysis talaga? Yung process ng DNA analysis starts with DNA being extracted and purified from a biological sample. In our case, katulad bodily fluids, example nito would be blood. Ngayon, ang DNA analysis, para makonduct mo siya, meron kasing iba't ibang techniques or iba't ibang test na pwedeng gawin katulad sa presumptive at saka sa confirmatory test. Pero for our example, next. For our example, gagamitin natin itong isang type of DNA analysis which is called short tandem repeat STR for short analysis. So, ang STR analysis, ang ginagawa nito, yung sections ng ating DNA between 1 to 5 nucleotides, ang ginagawa nito, may tinatawag tayo STRs. Yung STRs na to, yung nga sinabi ko, section siya ng DNA between 1 to 5 nucleotides and nagre-repeat siya several times sa specific points ng ating DNA sequence. Ngayon, yung analysis na to, Yung analysis na to, ang ginagawa niya, ine-examine niya kung ilan yung number of times na yung isang certain STR sequences ay re-repeat sa ating DNA. Now, yung mga repeats na to, nag-occur siya sa same location sa DNA ng bawat tao. Pero yung amount of times na magre-repeat siya is different sa bawat tao. Bale, in short, short tandem repeat or STR analysis, technique siya na ginagamit to analyze genetic variation in a person's DNA. Okay, it involves identifying yung small sequences of DNA, yun nga STR, that are repeated throughout sa ating DNA. Now, para ma-perform ang isang STR analysis, ang unang step natin is, of course, kukuha tayo ng sample DNA. And sa ating example, sa blood. Ngayon, yung DNA na yan ay i-extract at i-purify. And the next is, sa specific regions ng ating DNA na may STR sequences of interest, ang gagawin sa kanya, i-amplify siya using a technique called PCR or polymerase chain reaction. This amplifies the amount of DNA present in these regions, making it easier to detect and analyze. Ang meaning nito is, yung amplify is, pinaparami niya yung DNA na may STR sequences para madali natin siya ma-detect at ma-analyze. Ngayon, yung amplified DNA fragments, yung kakasabi ko pa lang, are then separated by size using a process called electrophoresis. This involves applying an electric charge to the DNA fragments, causing them to move through a gel matrix. That the smaller fragments move more quickly through the gel than larger fragments, creating a distinct band that can be visualized. Mangyayari dyan, maghihiwala yung mga small fragments dun sa larger fragments. And then, ang mangyayari, yung resulting fragments na yon, pwede mo siyang gamitin pang compare to a reference sample to determine kung nagmamatch ba yung mga fragments na yun sa isa't isa. By comparing the patterns of STR repeats in the DNA of different individuals, pwede natin ma-identify yung genetic variations niya. And pwede din natin ma-identify kung sa kanya ba talaga yung DNA na yun. Ang kagandahan ng STR analysis is that pwede mo siyang gamitin with DNA samples na lower yung quality niya. Which means kahit yung mga trace amounts lang or onting amounts lang ng DNA, kaya niyang i-analyze. And before I end my presentation, a quick recap and clarification. Ang DNA analysis, different siya sa confirmatory test. Dito sa DNA analysis, ina-analyze niya lang mismo yung genetic makeup ng body fluid para ma-determine kung sino yung may-ari. While sa presumptive and confirmatory test, for checking lang siya dun sa identity ng bodily fluid mismo. And that's all for my report, and I'll be passing it now to my co-member, Maria Lourdes Magtaas, to report the admissibility of physical evidence.
Since we all know the process of acquiring and analyzing physical evidence, let us move forward and discuss the admissibility of physical evidence. According to Section 1, Rule 130, Rules of the Court, objects as evidence are those addressed to the senses of the court. When an object is relevant to the fact in issue, it may be exhibited to, examined, or viewed by the court. The definition covers any material that may be seen, heard, smelled, felt, or touched. They are which we call sensual evidence. These are further grouped into, first, those exhibited to the court or observed by it during the trial, like wounds or scars in the body in physical injury cases. And another division are those which consist of the results of inspections of things or places conducted by the court or ocular inspections outside the court, such as the observations made by the parties that are duly recorded, pictures, and other representations that may be used, such as sketches and measurements. And lastly, those tests or experiments or practical tests or demonstrations, provided the conduct of experiments is subject to the discretion of the court, wherein analysis of physical evidence come into play. On that note, there are certain requirements that will deem the physical evidence admissible in court. First requirement is relevance and competency. The evidence must be relevant to the case at hand and must also be competent, meaning it must be legally obtained and reliable. The second requirement is authentication. Authentication is a process of proving that the evidence being presented in court is the very evidence involved in the event. This is important for two reasons: to prevent the introduction of a different object, because authentication ensures that the evidence being presented in court is the same evidence that was collected at the scene of the crime or during the investigation. This prevents the possibility of someone substituting the evidence with a different object to sway the outcome of the case. And next, to ensure the integrity of the object. Authentication also ensures that the evidence has not been significantly altered or contaminated since it was collected. This preserves the integrity of the object and ensures that it can be relied upon as evidence in court. With that said, the process of authentication involves several important component elements, and the first is a proof of identity. This can be established through the testimony of a witness who can identify the object being presented as the same object that was collected at the scene of the crime or during the investigation. There are actually two ways in which a witness can establish proof of identity. First is through markings placed by the witness upon the object. A witness may have placed some form of marking on the object, such as their initials, a date, or a signature. These markings can help to establish the identity of the object and prove that it is the same object that was collected. Second, peculiar characteristics of the object. The witness may be able to identify the object based on certain physical features that set it apart from others of the same kind or class. For example, a hole caused by burning in a sweater or a broken hilt of a knife could be used to establish proof of identity. In either case, the witness must have a basis for their identification, and this must be established through their testimony in court. This helps to ensure that the evidence being presented is reliable and can be relied upon in the decision-making process. Second is proof of identity and integrity. By proving that there was no break in the chain of custody in the event of the object passed into possession of different persons. When the object passed into the possession of a stranger, then there is no doubt as to the integrity, if not identity, of the object. And lastly, C, proof of identity. Proper preservation of the object is also an important component of authentication. This involves showing that the object was kept in a secure place as to make contamination or altercation difficult, and that it has not been brought out until its presentation in court. Hence, if all of these elements are not fulfilled, there will be improper authentication. If the object is not properly authenticated, it may be excluded upon proper objection, or it may not be given any evidentiary value. Thus, in a criminal case, reliance on improperly authenticated evidence may be a ground for acquittal. The scientific tests that are judicially accepted are the following. First, paraffin tests, although they are not conclusive that a person did or did not fire a gun. Second is the lie detection test, wherein the result is not as admissible as evidence in the Philippines, but I think in some countries it is also used. Third is firearms identification evidence or ballistic test to determine whether a bullet was fired from a particular gun. Fourth, question document test and handwriting analysis. Fifth, drug test on a person. Sixth, toxicology or test of poison. Seven, psychiatric examination. Eight, voice identification test. 9, fingerprinting. 10, identification through dentures. 10, genetic signs such as DNA or blood test. Now we head on to the admissibility and weight of DNA profile. The case of People versus Vallejo and People versus Yatar adopted the Dober test, settled the admissibility of DNA tests as objective evidence wherein it stated that applying the Dober test, the DNA evidence appreciated by the court ACO is relevant and reliable since it is reasonably based on scientifically valid principles of human genetics and molecular biology. As to the weight and probative value, it depends on the observance of certain requirements known as the Vallejo guidelines. To note, it is how the samples, both evidence and reference, were collected, how they were handled, the possibility of contamination of the samples, the procedures followed in analyzing the samples, whether the proper standards and procedures were followed in conducting the test, the qualification of the analyst who conducted the test, the possibility of human error in conducting the test, and lastly, the manner in which the results were presented and explained in court. The weight and probative value of DNA evidence may also be affected by other factors, such as the quantity and quality of the DNA samples, the presence of multiple contributors to the DNA profile, and the presence of potential sources of error or bias in the analysis process. Overall, while DNA evidence is generally admissible in court, its weight and probative value will depend on a variety of factors that must be carefully considered and evaluated by the court. The Vallejo guidelines provide a useful framework for assessing the reliability and credibility of DNA evidence. But courts must also be mindful of other potential sources of error and uncertainty in interpreting and applying this type of evidence in specific cases. And to further elaborate the admissibility of a physical evidence, allow me to discuss the chain of custody. Chain of custody refers to the chronological documentation or paper trail that records the sequence of custody, control, transfer, analysis, and disposition of physical evidence. It is essential to establish and maintain the chain of custody whenever evidence is collected and presented in court to ensure that the evidence is admissible and reliable. Adherence to standard procedures in recording the location of the evidence, marking it for identification, and completing evidence submission forms is crucial to maintaining the integrity of the evidence. Any break in the chain of custody or failure to follow the proper procedures can compromise the credibility and admissibility of the evidence in court. The chain of custody is crucial for maintaining the integrity of evidence, as mentioned a while ago, including DNA analysis, including DNA evidence. Continuity of possession must be accounted for from the crime scene to its final destination. Proper evidence control involves a clear chain of custody record, signature, and date of receipt, description, and marking of evidence, evidence seal, and secure storage. Adhering to these procedures ensures that evidence is properly identified, tracked, and protected from tampering or contamination, preserving its credibility and reliability in court. Here is an example of a chain of custody form where an officer will write the evidence in his possession together with its quantity and remarks. It also highlights where the evidence have been delivered, examined, and turned over, as well as the people involved in handling it. And now, to discuss the subpoena and role of an expert witness in a trial, here is Samantha Nicole Barreto.
Receiving a subpoena is a bit unsettling for a layman. Some people lose their sleep and get agitated in anticipation of their appearance in a hearing or investigation after receiving a subpoena. To overcome this feeling, it is important to understand the true significance of a subpoena. Subpoena is a writ or notice issued under the authority of a court to compel the appearance of a witness at a judicial proceeding, and the disobedience of which may be punishable by contempt of court. So where does a subpoena usually come from? Aside from the court, the Office of the Prosecutor, Office of the Ombudsman, National Bureau of Investigation, House of Representatives, and the Senate of the Philippines, among others, can issue a subpoena. But why would you receive a subpoena from the prosecutor's office? In the office of the prosecutor, the assistant or investigating prosecutor to whom the complaint is assigned shall either dismiss the complaint if he finds that there are no grounds to continue with the investigation, or issue a subpoena to the respondent, attaching to it a copy of the complaint and its supporting affidavit and document. The purpose of the subpoena in this instance is to require the respondent to file his counter affidavit within 10 days from receipt of the subpoena and the complaint. If the respondent cannot be subpoenaed, or if subpoenaed does not submit a counter affidavit, the investigating prosecutor shall resolve the complaint to determine whether there is a probable cause to hold the respondent for trial. Pero again, hindi ibig sabihin na nakatanggap ka ng subpoena from the prosecutor's office may kaso ka na. May nag-file ng complaint against sa'yo, kaya ngayon, binibigyan ka ng chance para masabi yung side mo. So how about when you receive a subpoena from the court? It commands you to testify as a witness at a specified time and place, and or to produce documents or other tangible objects in legal proceedings. And again, failure to respond to a subpoena is punishable as contempt by either the court or agency issuing the subpoena. The Philippine rule on subpoena is found in Rule 21 of the Rules of Court. And let us now proceed to the two kinds of subpoena: subpoena ad testificandum and subpoena duces tecum. Subpoena ad testificandum is when the person will have to attend and testify at the hearing, the trial of an action, an investigation conducted by a competent authority, or for the taking of his deposition. Here, to testify means to make a statement based on personal knowledge, and to have personal knowledge is to be able to perceive events, circumstances, or occurrences, and perceiving can make known his perception to another. In short, iniimbitahan kang umattend dahil kailangan ang statement mo sa isang kaso. The second kind of subpoena is subpoena duces tecum, meaning subpoena for production of evidence. It requires the person subpoenaed to bring with him books, documents, or other things under his control at a specified time and place in a court hearing or a deposition. In short, pinapatawag ka na dalhin ng isang bagay na konektado sa kaso. Moving on, let's proceed to the two kinds of witness who can receive a subpoena from the court. So an expert witness gives evidence of his opinion, supports his evidence by the experiments which have been performed by him in the absence of the opposite party, and gives the rules and reasons which supports his opinion. While an ordinary witness is a witness of fact and gives evidence of those facts which are under inquiry. It is available to the opposite party for veracity, and gives evidence of what he has perceived by senses. So in short, for an expert witness, you have to provide evidence as to why you have arrived at that conclusion, like what was your basis for it. While an ordinary witness just has to state what he has seen or heard, and then the pieces of evidence should match to what he or she is saying. In terms of dealing with expert witnesses, a party may use a subpoena duces tecum to request an expert witness to bring their notes, handbooks, papers, or research materials for review. In contrast, a subpoena ad testificandum may be used as part of an early attempt to bring an expert into the course for a review of their credentials and background for possible changes or attempts to exclude their testimony in the future. A subpoena shall state the name of the court and the title of the action or investigation, shall be directed to the person whose attendance is required, and in the case of a subpoena duces tecum, it shall also contain a reasonable description of the books, documents, or things demanded which must appear to the court prima facie relevant. And here is an example of a subpoena. The top part shows the name of the court, the city and branch, and the name of the complainant and the accused on the upper left side, while the kind of subpoena and the criminal case number is written on the upper right side. And in this example, the purpose of the subpoena is for the doctor to testify as a witness and bring the medical certificate of the deceased. In the body of the document, the place, date, and time of the hearing are stated. And I notice that failure to attend is punishable under the law. In the last part, the names of the judge and lawyer are also stated. And the following are the possible questions that may be asked to an expert witness subpoenaed by the court. Have you written any articles related to insert the type of injury here? How many cases have you handled that involve this type of injury? Did you perform any tests? What test did you perform? What were the findings of this type of test? How do those findings support your conclusion? What information did you review to help you reach your opinion? Did you employ any evidence based methods in reviewing this information? Is the history of the trauma consistent with the nature of the injury? And now, to summarize our report, we have concluded that there are two types of wounds, which are blunt force trauma and sharp force injury. Under blunt force trauma, we have abrasions, contusions, and lacerations. Under sharp force injury, we have incised, puncture or stab wounds, and gunshot. While fractures and dislocation can both be a result of blunt force trauma and sharp force injury. As for the documentation and measurement of physical evidence, we have three vantage points, which are the mid-range, close-up, and close-up photograph with scale. Moving on to the types of bodily fluids, we have excreted and secreted bodily fluids. We have also discussed the proper documentation and collection of bodily fluids. Two types of analysis were also mentioned, the presumptive test like the luminal and Walker test, and the confirmatory test such as the RSID test for human blood and semen. As for DNA analysis, we have short tandem repeat or STR analysis. And lastly, we have also covered admission of physical evidence. Under this is the subpoena, rules of the court, and chain of custody. And the last part of our report talks about the future of DNA evidence. The Philippines has taken a major step towards modernizing its criminal justice system by recognizing the power of DNA evidence. The 2019 DNA Analysis Act created a national DNA database, providing a valuable tool to aid in the investigation and resolution of criminal cases. The legislation also establishes clear guidelines for the collection, analysis, and use of DNA evidence in legal proceedings, providing a solid foundation for the use of this technology in the country. Despite this advancement, there are still challenges to full implementation of DNA evidence in court. One major obstacle is the need for more education and training for judges, lawyers, and law enforcement officials to ensure the proper handling and interpretation of DNA evidence. In addition, the cost of DNA testing and analysis remains a barrier in some cases. Nevertheless, the future of DNA evidence in court in the Philippines looks bright, with continued technological advancement and increasing awareness and training on its issues. As the legal community becomes more familiar with the benefits of DNA evidence, it has the potential to revolutionize the administration of justice in the country, bringing a new level of accuracy and fairness to criminal proceedings.